All right, if I can have everyone's attention, it's my pleasure to introduce Priya Bhatia. She is the Acting CEO and Executive Director of Professional Development and Competence at the Law Society of Ontario. She's a senior leader with demonstrated experience in complex operational environments. Her previous roles at the Law Society include Executive Director, Professional Development and Competence, and the Director of Licensing and Accreditation. So please join me in welcoming Priya.
Good afternoon, and thank you so much for having me today. I'm going to, full disclosure, admit that I have a really bad cold, one of those spring colds that we dread, so you'll have to forgive me if my voice is a little hoarse. Hopefully I'll get through without too much trouble. So, just want to make sure I have the remote. All right. So, I'd like to focus on bringing a number of updates to you today, primarily around our core functions, but also around some recent events that have been going on at the Law Society. We're always engaged with you and interested in being here with you, so I really want to thank you for having us. So, this is the elephant in the room, and we're just going to go there. The revelations around the previous CEO's compensation have naturally caused serious concerns for lawyers and paralegals, and have, I mean, to be truthful, have rocked the profession to some extent, and we know that. And we have been working very hard at restoring your trust in us. And you'll see from the Convocation News and other information you're getting from the Law Society that we released a number of things. In March, we released the report and legal opinion of Dennis O'Connor. Then in April, we released a report indicating that the Treasurer and Convocation are committed to implementing an action plan focused on the recommendations in the O'Connor report, but also on some broader governance reforms over time. This is a three-stage action plan, and we have now retained a governance expert, Dr. Richard LeBlanc, who is a well-regarded and renowned expert coming out of York University, to support this work. The intention is to move quickly on this work and to have most of the recommendations related to the O'Connor report in place by the end of June. Some of the broader recommendations will take time, and you can look to a fall report or update on those recommendations. We are very interested in your input, so while we continue to do this work, we also encourage you to engage with us, and we have a number of ways you can do that. I have my contact information at the end of this slide, but you also will have access to our external engagement folks. A few people are here from that group today. So we really want you to feel that you can come to us if you have thoughts, concerns, or questions along the way. Other elephant, LSO Connects. So first of all, let me just say that I want to thank all of you for sticking with us, okay? So we know this was a huge lift for all of you, a change that had, impacts beyond what we may have thought at the beginning. We know that there were challenges, as there always are with a massive change like this. And it goes without saying that this was the biggest business and systems transformation we've ever done at the Law Society, and we know it had far-reaching impacts. And we couldn't have done it without you. Just to give you a little bit of insight into where we were before we did this, we didn't undertake this lightly. This was a much-needed change, really rooted in the fact that we had very old legacy systems, as one often does when you are a large organization with a steeped and storied history. So those systems were no longer serviceable. They were not being supported, and they definitely didn't provide the kind of modern platform we need to regulate today. So the size and the scale of that transformation was massive. We were able to keep our core functions going for the most part, and we got 70,000 licensees to register for an account and essentially comply with the annual obligations. And again, that was in no it was largely due to your cooperation and, of course, our efforts to get you there. So I just wanted you to know that these are the compliance rates we've had, and they are very comparable to previous years, which is good. But where do we go from here? We know there are still challenges and questions and really requests from some of you on to how we can make this more usable. And we know that, and we are listening. For instance, on the bulk payment issue, where law firms would pay for licensees working at the organization, I think we kind of missed the boat on that, to be honest, and we know that. So we are working towards a new process. We did end up getting 500 law firms onto bulk payment as we got a sense of the fact that we needed to make some adjustments. But now we're working on a revised bulk payment process for 2026, and we are consulting with law firms on that process. So we will allow law firms to enroll in that at any point in the year. For instance, you'll be able to see a list of licensees who work at your organization as part of this new functionality. And it will be way easier for you as a licensee to indicate that your law firm is paying your fee. We're looking to create more efficiencies and opportunities as we move forward, and you can expect that the Law Society will be announcing opportunities to participate in some of that through user focus groups in the coming months. Our goal at the end of the day is to make this easier for you and to let you practice and focus on serving your clients, and let us do the administration and try to make that as seamless as possible. So in terms of professional regulation, this is, of course, one of our core areas at the Law Society. I want to show you a little bit about our sort of overarching model, first of all, which is here reflected on the slide. This is actually a strategic priority that was approved by Law Society Convocation as part of this venture term. The idea being that traditionally, in recent years, we've had our competence arm and our regulatory arm kind of work side by side, which is good, but we really need to see them working more closely together. Upstream proactive competence supports are the answer to a lot of our regulatory issues. And so we have been taking steps to fulfill this strategic priority over the last couple of years, and one of them is simply getting the teams together more often to explore and exchange information. The other more sort of pointed one is to ensure that our competence initiatives themselves are rooted in evidence around regulatory risk, and that our regulatory approaches take into account a range of approaches, including remedial ones. I'd add that the new technology, the LSO Connect system, is a massive step forward for us in this way because, of course, when the systems are separate, the information is separate, and it's really hard to have that evidence-based collaborative approach. So, turning to the core, some of the core things we do in professional regulation, of course, we process complaints against lawyers and paralegals, and the slide shows a trajectory of complaints since 2018, annual complaints, and you can see that the increase was, there was an increase in 2023, but we're actually sitting kind of in the same space for 2024. Complaints come in through LSO Connects now, so the public uses LSO Connects. It's also used by licensing candidates, and we received some good feedback about that because rather than sending an email and kind of waiting till you get a request for documents, the public can provide the documents and a full accounting of what is the subject of their complaint, and then get a more speedy response, because of course our processing times are always a challenge in regulation because there's a lot to look at and we have to follow due process, but this makes that easier. So disposition of complaints, the vast majority are resolved early without proceeding to a formal investigation. So intake and resolution is doing the heavy lifting and resolving and the magnitude of 5,600 complaints annually. This doesn't mean they're all closed immediately. It actually contemplates a variety of approaches. Everything, we want to be constructive about this, work with licensees, especially licensees who have insight. Complaints happen, we understand that, and generally speaking, licensees are often very committed to learning from this. And that's the best thing for a profession, a self-regulating profession. So we would, be working with the licensee to direct them to remedial supports, providing coaching, advising, in some cases, education, and sometimes regulatory guidance. Less than 800 of these complaints were transferred to investigations, and only 209 of them went to a hearing. So the machinery, that heavy machinery for investigation and litigation, is really reserved for the most serious of complaints. And we know that the majority of our complaints are really around client service issues, communications, practice management, things that you would also hear from Law Pro. That's how things are looking these days for disposition of complaints. And finally, I just wanted to draw your attention to the risk-based approach we are using in professional regulation. Obviously, we've always used a risk-based approach. That's how regulators have to work. That's how most organizations have to work. You don't have infinite resources. But I'd say that this has been sharpened in the last few years, which is important because, of course, as volumes go up, as complexity goes up, as we know we live in an era of complaint, and and that's ever more true with social media and other channels for things to occur. We need to support that. So, in high-risk cases, we are assessing risk earlier, so we can make some more timely determinations around interim measures that might be needed to protect the public. So, for instance, over the last year, there was a much higher number of interlocutory suspensions and summary hearings than in previous years. And that risk-based approach allows us to also allocate, to divert complaints that don't require that kind of treatment to the more remedial approaches that I talked about. So in 2024, we actually sought 29 interlocks and obtained 26 compared to 8 in 2023. Just quickly on capacity issues, this is another area where we are seeing some successful outcomes, where we're resolving things without going to a formal hearing, where we are exercising compassion and looking actively towards alternative solutions to ensure the public remains protected, but that we're also mindful of the realities of practice and taking into account what we know about mental health issues and wellness in the profession, which is also a priority. So these cases are more challenging. Naturally, they're more resource intensive, but we are closing a number of these with undertakings that remain in effect, where there might be terms, such as ongoing care and treatment by a regulated professional, or there may be some reporting involved to ensure that that things are being followed through upon. And if things are not working, then we will deal with that in terms of maybe in that case the undertaking will provide that the licensee would stop practicing if they're unable to fulfill the terms of those undertakings. So out of the 6 capacity cases closed in litigation services in 2024, only 1 involved a licensing hearing. So we really are diverting these where we can. So on to competence. This is the other main arm of the Law Society's work, as you all know, and we are committed to elevating competence through a range of initiatives and programs. And you are familiar with those because, of course, you are all familiar with the CPD requirement and some other initiatives that I want to talk about. So this is the Family Legal Services Provider initiative that was approved a couple of years ago and really launched in the fall. This credential, as you know, allows paralegals to provide certain family legal services. This was approved by Convocation after extensive consultation, and we're talking several years, and is a component of the Family Law Action Plan that the Law Society's committed to with the goal of improving access to justice in family law. The scope of an FLSP is fairly circumscribed. It is limited to things like process navigation, joint and uncontested divorces, filing domestic contracts, change of name applications, motions to change child support, and responding to enforcement proceedings. This was very much part of the model that Convocation adopted to ensure that this is a feasible and viable way to go forward, to ensure the public remains protected, and that we have an opportunity to get some insight into whether this has actually improved access to justice. So we are now, we're just ending the first cohort training program, which has been offered in partnership with Fanshawe College, and it's a rigorous program, competency-based, has online coursework, field placement that would be taking place actually right now. This is the time they're doing those field placements, and a competency-based assessment that is going to be delivered by Fanshawe. So graduates of the FLSP will be coming to the Law Society for authorization once they've completed all of their requirements, and we're looking forward to our first group of FLSPs being out in the world to provide legal services. Interestingly, we had a huge demand for the program, and we weren't really sure that would be the case when you have a narrow scope, an untested idea, at least not untested in Canada, and we ended up with 528 applicants for 120 places in the first program offering, so that's very encouraging. So the next program begins in September. Applications are now open, and of course we are also evaluating this initiative to see that it meets the principles. Another, I think, very important initiative that I think you will all be interested in is the launch of the Foundations of Sole Practice program and requirement. This came out of the Competence Task Force and the research and consultation they undertook around risk and opportunities for newly formed sole practitioners. And they consistently found that practitioners who are working in sole and small environments, and particularly in sole environments, do not necessarily have access to the education, the skills, the support that they need. So this is just directly responsive to that and requires all sole practitioners to take this course as of January 1st of this year. So if you're already a sole practitioner, you're off the hook. But guess what? You have access to the course if you'd like to take it. And actually, it's interesting, I was looking at our stats, and a number of those who are enrolled in the course are not required to take it, but are taking it because they have some interest. Now, this could be someone who's thinking of becoming a sole practitioner, wants to see what's involved. We really encourage that. That's an excellent way to determine if you are prepared to run a small business, because that's what this is. The course is very practical. It is business-oriented. It is about client service. It is about trust account management. It is about how to bill. You know, how do you want to set up your practice? You know, how do you do all these things that people don't always talk about, because we are, of course, very focused on substantive law. But these are the things that keep us up at night. These are the things that trip us up, and we wanted to acknowledge that and provide support for that. And another initiative that I think is quite important is the client contingency planning requirement that also began this year. It requires lawyers and paralegals in private practice to develop a plan for the preservation and carrying on and winding up of their professional businesses. This is a risk mitigation strategy for the public, for clients, so we don't have practices abandoned. If a lawyer or paralegal is unexpectedly able to continue with the retainer, just as you are managing these contingencies in your personal life, you need to manage your practice in this way. This came out of work that was done by Convocation in the professional regulation space, considering the work that we do in trustee services, which is immense and has been growing year in, year out. And this was following consultation. The model that we came up with has been revised. So it was originally a lot bigger. It's now focused on making sure that everyone has an administrator, that there are certain accesses that the administrator has to certain technology and resource records in the firm. And we are really interested in helping you with this if you are having trouble with it. So there's templates, resources, guides on our website. You can also call us. If you call the Practice Management Helpline, they will walk you through it. If you're having trouble finding an administrator, you can call Trustee Services. They will help you as well. It's just a few minutes on general resources for lawyers and paralegals. let's just talk about the Great Library, one of our oldest resources at the organization. So first of all, there are some changes taking place at the Great Library. We're currently facilitating a request from the Ontario government to vacate space at Osgoode Hall that has been owned by the province, but has been historically part of our space. So we recently provided that office space back to the province for judges and admins for offices, because of course we know that appointments are occurring and there's need for space. So that hasn't disrupted services. If you come to the Great Library, you wouldn't notice probably anything. And if you're accessing the Great Library remotely, they're able to serve you. The services that we offer, of course, are a range from legal research support, which we did. I think we supported about 10,000 of those in 2024. We have a document delivery service. You can see we have a lot of online databases. You or your staff can request copies of cases, legislation, and other legal materials. So in addition to, of course, your local county library, you have access to the Great Library to complement those services. We will send you things via email or interlibrary loan if you want to receive them at your county library. And the digital collections, of course, are available to you. And of course, we work very closely with the 48 courthouse libraries across Ontario, and we maintain a union catalog for those libraries. So, and if you haven't been to the Great Library lately, I encourage you to come by. The cherry blossoms are in bloom, and it's quite lovely. Okay, so other practice supports, you can look to us for a number of supports. The website houses all of it. That's an area we're also looking at some point. We're working early stages of revising the website because we know that people have trouble finding things. But there are a wide array of resources there. Everything from templates, guides, checklists. I'd say our two most popular resources are our practice management guidelines and our bookkeeping guides, which we update regularly, so they are current. Some newer resources to think about, things like the client identification and verification questionnaire, which will actually, you will put information in and it will guide you through what you're supposed to do, because we know that in particular virtual verification with authentication has been a bit of an area of confusion. Even saying those words is confusing to me. The guide to client management and how to help foster those strong client relationships. The guide to file management, which we all need to know how to do, even though we don't really love doing it, does provide you with that step-by-step. A new guide to navigating client capacity concerns is a great starting point if you are dealing with clients whose capacity may be diminished. And finally, the Responsible AI Toolkit. And I think you are having a session. I think Dan Pennington's coming tomorrow to give you his take on generative AI. But this is a really great starting point. We've got the white paper that was written by our Futures Committee. We've got how-tos, we've got questionnaires, and we've got some other resources that can help you just start understanding the capabilities and limitations of generative AI and how to use it ethically and safely. So I encourage you to look at those. A couple of other things I think you're all familiar with. Coach and Advisor Network. I've been here to speak about CAN before. We've had good uptake and really, really good response to that. That program started in 2016, and so I guess we're coming up to 10 years now. Coaches are supporting best practices and skills over a few months, and advisors will assist you with your substantive and procedural law inquiries. So if you don't have someone to pick up the phone and call or to walk down the hall to ask, you can call the Coach and Advisor Network or reach out via, we have a digital platform as well, and be paired with someone who will spend time with you on your client file, which is, I think, probably the most popular aspect of this service for obvious reasons. Feedback has been positive, as you can see. Approval ratings are high on that. And of course, if you haven't ever had to call the practice management helpline, that's great, but it is there for you. It is a confidential service that answers your questions about rules of conduct and professionalism and practice management topics. And we have a very good team doing that, and they are ready to help you with any of those issues. So we, of course, are always engaging in more policy work, and some of the initiatives here are listed here with some deadlines, three that are occurring or have concluded. We recently finished a consultation on proposals to increase transparency in regulation, and that was a consultation that really helped us and is helping us refine those proposals. So you can expect in the coming months to hear back from Convocation on where that's going. So thank you for engaging if you did that. I know FOLA had a submission. I'm sure some of you might have also sent in your individual submissions. We have two other ongoing consultations that are closing soon. The Equity and Indigenous Affairs Committee is seeking your feedback on the implementation of an Indigenous cultural training course in response to TRC Call to Action 27. There are two elements to this course. One would be to provide an opportunity for the profession to engage in reconciliation with Indigenous peoples by learning more about histories and experiences. And the second is to improve your own competence in cultural competence, values, and unique legal needs of this community from a client perspective in terms of how you would serve them. So I think you have provided a submission on that. I want to thank you for that. We welcome further comments from any of you. And the feedback, the consultation for that will close this week. And finally, the third consultation is coming out of the Paralegal Standing Committee. And they are looking for feedback on the potential expansion of paralegal scope to include certain appeals and judicial reviews before the divisional court, because at present, if the matter is before a small claims court and it is appealed or JR'd, the hearing would be before the divisional court, and paralegals are not authorized to represent parties there. So we would love to hear from you on that. Consultation closes at the end of this month. And I'm done my presentation, but I'm pleased to take questions within the time that I've been allotted. I have no idea what time it is, so that's Jennifer's job, I suppose, or maybe Bill's. Oh, it's yours. Okay, so and also I encourage you to contact me at my if you ever want to reach out. And I would.